All right. I'm just going through my court records. I was going to see if I got a new lawyer this week, and of course I didn't get one. But I was looking uh, for the original trial where the cops came over and said I didn't have any numbers on my mailbox. They specifically came out to target me in my mailbox. If you look at the RICO suit, it's a common tactic the Pasco Sheriff's Office uses to target citizens. But anyway, the original, I got a ticket for my mailbox. It was the second time they came out to my house. Prior to that, they gave me a ticket for a noise violation and for an unregistered vehicle. The unregistered vehicle got dropped. I was found guilty of a noise violation without any evidence. But like I said, the initial court case for the mailbox is gone. It doesn't exist. Pasco 6th Judicial Circuit wiped it from the record. No longer exists. So I'm just going through this. This is on appeal. I filed an appeal over this. They charged me with not having numbers on my mailbox, found me guilty of that, and a mailbox is federal. So they changed it to not having numbers on my house, and there's numbers on my house. It's just insanity. So we got 10 pages of this crap. They're citing also. This is just nuts. Preliminary statement. Citations to the record made by the readers are the appropriate page number record of appeal. Imagine having to appeal getting a ticket for mailbox numbers and then it being changed to a building code violation for having no numbers on my house, which there were numbers in the house. It's maddening. Nature of the cause. A Pasco deputy sheriff issued a non-criminal county ordinance citation on September 30th, 2018. The citation accused appellant of violating Section 9019 of the Pasco County Land Development Code. Specifically, the deputy wrote the following facts. At 7205 San Moritz Drive, I was unable to observe addresses on the mailbox on the roadway. There are no numbers listed on either side of the mailbox. So, Pasco County has a major fentanyl problem like everywhere else. They talk about houses being broken into. It's crime-ridden. They made a trip out to my house over a mailbox? It's a targeting tactic. There are no numbers listed on either side of the mailbox. And here we go. Judge Frank Gray again, held a final evidentiary hearing on June 25th, 2019. I'm stuck with Judge Frank Gray for my entire life. This guy's cleaning up the streets about mailbox numbers and then saying your house has no numbers. And the same numbers have been in the house since 1976. No recording of the witness testimony or arguments was preserved. It's not a court of record. You have to make your own record because there's no record there. So yeah, no recording of the witness testimony or arguments was preserved. The ordinance provides a standard for the physical numbering of houses and requires numbers must be legible from the street with figures not less than 3 inches high for the residents. There's a freestanding mailbox serving the building or house. Easily legible numbers shall be affixed to the mailbox. At trial, Judge Gray found as follows. The appellant denies the allegation. The court found appellant guilty of the violation. So they're talking about a house, the house numbers, but then they're gonna make it the mailbox. And Frank Gray's presiding. Summary of the argument. Appellant ignores the content requirements mandated in rule blah 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 for appellate briefs, declining to summarize their arguments, provides standards of review, provides citation appropriate authorities. Instead, she filed 7 single-space pages containing generalized complaints about the conduct of the trial, including failure to grant a continuance, failure to grant unspecified ADA accommodations, attacking the quality of witness testimony, reciting evidence she failed to produce at trial, etc. So, seven single-spaced pages. They want double-spaced. They want in Courier Times New Roman. 7 single-spaced pages. That's what they're arguing about. It's not double-spaced. This is an appeal. You got to be an appeals lawyer over mailbox numbers. And once again, I'm asking for ADA accommodations. They're unspecified. We're not going to worry about them. Aptly further, without citation to any legal authorities, denies the trial court had jurisdiction over her and denies the county has jurisdiction over mailboxes. Anybody that has a second grade education knows that mailboxes are a federal thing. It doesn't even matter because they threw out the federal part, or the mailbox thing, and charged me with not having numbers on my house, and then the whole case is deleted. It's totally deleted. Off the docket. You can't find it. So, appellate further without citation to any legal authority. that denies the court has jurisdiction over her and denies the county's jurisdiction over mailboxes. They do not. Finally, she complains her Fourth Amendment rights were violated and complains she received no warning. No, they just came over, peppered me with $800 in tickets. Look at any article about the Pasco sheriffs. They're given mailbox citations, overgrown grass, unregistered vehicles, you name it. They're hitting you with it. And there's no warnings. They'll just hit you with these massive fines. But it doesn't matter because they stole my house anyway. Appellee will attempt to respond to these arguments by demonstrating the evidence was sufficient. There's no error in the face of the record. The appellant received due process. They just talk in circles. They have no regard for the law. And this is back in 2018, 2019. The same thing over and over. Had nothing but targeting by the Pasco County government, the Pasco County sheriffs, and this Frank Gray guy. I'm asking for ADA accommodations way back then. They said they're unspecified. The guy told me, you're not disabled. You can read and you can write. This guy's a big problem. So evidence was sufficient. They'll counter everything. They'll make stuff up. This is ridiculous. Issues concerning evidentiary sufficiency is not reviewable where there is no transcript of the trial proceedings. So you cannot appeal because it's not a court of record. So you're not allowed to appeal it because they won't keep a record. You ask them for a record, like the trial against my mother, my trustee. I asked for a trial by jury and a court reporter. But they just throw the whole case out. And then you go to appeal it. It's the same thing. You can't appeal it. There's no records. There's no nothing. It doesn't matter. So yeah, issues concerning the evidentiary sufficiency are not reviewable where there's no transcript of the trial proceedings or stipulated statement of evidence. However, an error which appears on the face of the final judgment is reviewable. They will hunt you down like a dog to the end of the earth over targeting performed by the Pasco Sheriff's Office. DSA would affirm costs and fees. No error appears on the face of the record. In this case, there's no error on the face of the record. The record contains the following evidence. But where is the record? A copy of the citation charging document. The citation shows the arraignment date was October 29th, 2019. A copy of affidavit of attempted service stating that in appellant presence, the issuing deputy announced he was serving her with a citation. She refused to come out of her residence and sign for it, and he left on the front door. They gorilla taped. Three citations, 3 tickets, all over my door. Ripped the paint off of the door they had kicked in prior. They put it over my peephole so you couldn't see out. There's no way I'm going out because you're gonna get beat up and you're gonna be taken to jail. There's no way I'm stepping out for armed gunmen. Motion to dismiss filed by appellant in 2018. The motion alleges generally that the unlawful search and seizure occurred. So they came out specifically to my house to look for mailbox numbers. They wrote the ticket at a time they were not even there. Unlawful search and seizure. What gave them probable cause to come out and look at my mailbox numbers? Because there was a call made. Was it about a mailbox with having numbers? A traverse filed by the county's prosecutor. They're filing traverses, demurs, and traverses. The traverse acknowledges the applicant's attempt to allege an unlawful search and seizure, but correctly respond that is not a proper subject for a C4 motion to dismiss. A C4 motion to dismiss is when they want a C4, and if you look at a C4, the person that's charged has to agree that there are no disputes in the material facts. and that you're citing grounds for a different, like you don't agree, like you don't disagree with anything the cop said or anything that the prosecutor said. So it's a C4. That's like your only option. You have to agree to everything before it's dismissed. I don't agree to any of this shit. In order denying the motion to dismiss, a copy of the county ordinance appellant was charged with and violated admitted at trial. Never admitted anything. There was numbers on the mailbox. They were faded. There was numbers on the house. They were painted black on a brown background. Why did the cops come to my house for a mailbox? After they came and gave me tickets, they came back after giving me tickets for a noise violation with no evidence, and they went around and searched my property and saw my caravan. Didn't have the right plates on it. And that got thrown out. So there's photos admitted at trial. So an evidence transfer receipt in Decatur County's admitted composite copies of picture of mailbox. Where are these pictures? Photos admitted at trial. That this government will hunt you down over faded mailbox numbers. It was like a $200 or $300 ticket too. Further, appellant in her own brief to this court appears to admit to the inadequacy of number in her mailbox, stating, "It is completely dishonorable to attempt to charge me $150 when the mailbox is renumbered the next day. I'm a disabled person. My mailbox numbers are fading and the house is in foreclosure, only to be stolen by this court." And having a career criminal steal all my equity. Do you think I'm worried about the mailbox and its faded numbers? This is sick. Appellant was provided due process. In her brief, appellant alleges generally that she was not given a continuance, a chance to present her proof, unspecified ADA accommodations. They hate the ADA. And other general complaints about the process of trial. Pasco County is treating these statements as an argument that she was denied the due process of law. This is just crazy. It goes at 10 pages. Due process in a court proceeding demands that the defendant be given fair notice and a reasonable opportunity to be heard before a judgment is rendered. Where was my jury trial on this? You're not going to get one. You're just going to sit in front of Judge Gray. He's going to put on his little dog and pony show. I asked him to present evidence. He said, "You can't show evidence here." Further, an order adjudicating issues not framed by the pleadings noticed to the parties who are here or litigated below implicates due process concerns. They're citing case law over a mailbox. And that's in my cops playlist. You can see the field training officer and Deputy Robert Ashley, the rookie. He goes, "We got a call out here." The field training officer, "We got a call. She's getting ticketed regardless. Plus, it's good for our stats." In this case, appellant was given fair notice of the substance of the alleged violation, and you can't, the alleged violation and the original court case is gone. They disappeared it from the docket. Her motion to dismiss, although unsuccessful, demonstrates she was aware of the allegation that the number of her mailbox was alleged to be in violation of the county's regulation. How is the county regulating a federal thing? It doesn't matter. The trial was held almost 3 months after arraignment, following a flurry of pretrial motions and demands from the appellant. Just like normal, you file all these motions, and they don't get looked at. Screw you. We're taking your money. We're putting you in jail. That's it. And if you try to appeal, there's no record. There's no record of what happened before, and we're going to uphold the original decision. And these people are getting paid. How much money these people get paid to go after you after a mailbox? The issues were actually litigated by the parties as recited in the judgment. Judge Gray, this guy, he's a cancer to this earth, and he's a cancer to me. Judge Gray allowed her to file a motion to dismiss after the arraignment date and did not deny the motion until after a traverse was filed. When I got the traverse, I'm like, I'm not screwing with this anymore. Appellant's generalized complaints that she had no opportunity to defend herself or present her proof are without merit. These people have no merit. They're sickos. No merit, without merit. Just like when the first time I sued my trustee. You failed to state a claim. You failed to state a claim. It's usually you failed to state a claim for which relief can be granted. They just play around with word salad. And you never get a lawyer. You'll never get a lawyer. You can have a jury trial, they'll deny you a jury trial. And you can't get a lawyer because you don't qualify for one, or they just won't give you one. And they're just going to steal the money out of your pockets, just harass you at the end of the time. Finally, appellant argues she should have been given a warning up to 30 days to comply with the county's ordinance. Yeah, I should have been given a warning. Fix the mailbox numbers. I'll run down, I could put tape on there and write numbers on there. Or I could run down a Home Depot and spend a few bucks and put numbers on the mailbox for a house that's in foreclosure that they're going to steal regardless because their pensions are all paid out of it. So yeah, so I argue that I should have been given a warning and up to 30 days to comply. If you made a mistake, especially something so minor as having faded mailbox numbers, hey, can you get that fixed? Because the mailman's been able to find my house for 20-something years. But the cops are going to come out there and give me tickets for it. No ability to comply. You could have given me an afternoon. And I could have put numbers on the mailbox. Numbers that they liked. So yeah. So no warning up to 30 days to comply with the county's ordinance, and cites the section, whatever, in support. That provision of the county's code requires a code officer, as opposed to a law enforcement officer, to give a warning before a citation, but further exempts irreversible, irreparable violations from the warning requirement. However, subsection of whatever, same ordinance, upon which appellant relies states sworn law enforcement officers shall have the authority to enforce local ordinance violations and may do so without the issuance of a warning. These cops shouldn't be in charge of code enforcement. Why have code enforcement officers? And they're saying, oh, because they're given the authority to give a citation without a warning, then they just should go ahead and do it. Yeah. In this case, the citation was issued by Deputy Ashley, a sworn law enforcement officer. Therefore, a warning was not required in this case, and appellant's argument is without merit. These people are sick. They're absolutely sick. And if I felt like editing, I could put the body-worn camera footage where his field training officer said, we're out here regardless, and she's going to get a ticket, and it's good for our stats. And I cross-examined that guy on the stand. I've just had it. This county is just out of control. Absolutely out of control. And you know what? I never paid them. I would never pay them. I will never pay them. Like I said, this Gray guy, it's like he's been appointed to me for life. How many times have I dealt with Gray? This apparent noise violation, the unregistered vehicle, my stolen AR-15, my trustee twice, which he couldn't seem to hear. Tons of shit. And it's always this Gray guy. And he's always denying ADA accommodations. He's as crooked as a dog's hind leg. Like I said, you will not find the original case list. They have deleted it from all existence. All you can find is this appeal. There hasn't been a minute of my life, I would say since 2010, but it's actually since 2002, that I have not had to deal with the 6th Judicial Circuit or the Pasco County Sheriff's Office. I'm in North Carolina, and the Pasco Sheriff's is setting other deputies up to harass me and intimidate me. Tons of RICO suits. Never any RICO suits. And they're just allowed to keep doing it. Anyway, all this for a mailbox. And like I said, they changed it by a house not having numbers, and they deleted that. Because the house has numbers. You go look at any pictures at any time. It's the same numbers. It's 1976.